An Introduction to Constitutional Law, 100 plus Supreme Court Cases Everyone Should Know by Randy Barnett and Josh Blackman.
Enumerated powers in the Progressive Era. United States versus E.C. Knight, 1895. Champion versus Ames, 1903. And Hammer versus Dagenhart, 1918.
As the 19th century drew to a close, the progressive movement began to successfully lobby the states and later Congress to enact new political, economic, and social reform.
Later, we will study how state progressive laws were challenged as deprivations of liberty without the due process of law.
In this topic, we will study 3 cases in which federal progressive laws were challenged for exceeding the scope of Congress's enumerated powers. United States versus E.C. Knight, 1895, Champion versus Ames, 1903, and Hammer versus Dagenhart, 1918. In the first case, the American Sugar Refining Company purchased its competitors, including E.C. Knight. The federal government charged that the new firm would monopolize the sugar market nationwide. The Supreme Court considered whether this prosecution, brought under the Sherman Antitrust Act, could be supported by 2 of Congress's most important enumerated powers. First, Congress's power to regulate commerce among the several states. Second, Congress's power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers, including the power to regulate interstate commerce. The Supreme Court does not always consider both provisions, however, you should. Even in cases where the court only discusses the Commerce Clause, often the necessary and proper clause is also working in the background. Chief Justice Fuller, writing for the court, held that Congress could not prohibit the local manufacture of sugar even if it was intended for export to other states. Commerce, he wrote, succeeds to manufacture and is not a part of it. In other words, commerce comes after an item is manufactured. Study guide. Compare the interpretation of commerce in E.C. Knight and Gibbons versus Ogden. While the majority opinion didn't discuss the necessary and proper clause, Justice John Marshall Harlan's dissent stressed it. Harlan contended that the Constitution did not define the means that may be employed to protect the freedom of commercial intercourse. Rather, it gave Congress the authority to enact all laws necessary and proper for carrying into execution the power to regulate commerce. Justice Harlan then applied the means-ends test from McCulloch versus Maryland. What are the ends or goals the government is trying to achieve? The protection of trade and commerce among the states against unlawful restraint. Harlan concludes the ends are legitimate. What means did the government choose? Suppression of monopolies. Are those means appropriate? Harlan says yes. Because the means fit the ends, the Sherman Act is constitutional. In Knight, Chief Justice Fuller was in the majority, and Justice Harlan was in dissent. In our second case, Champion versus Ames, the roles reversed. Justice Harlan wrote the majority opinion for a 5-4 court. Chief Justice Fuller dissented. Champion v. Ames, also known as the lottery cases, considered whether Congress could prohibit the interstate shipment of lottery tickets. Study guide. Does the power to regulate commerce give Congress the power to prohibit commerce? Justice Harlan concluded that it does. Quote, lottery tickets are subjects of traffic and therefore are subjects of commerce. And the regulation of the carriage or transportation of such tickets from state to state, at least by independent carriers, is a regulation of commerce among the several states. The court did, however, adopt a limiting principle. Citing the 10th Amendment, Harlan acknowledged that Congress could not interfere with traffic or commerce in lottery tickets carried on exclusively within the limits of any state. Study guide. Compare the interpretation of commerce in Champion versus Ames, E.C. Knight, and Gibbons versus Ogden. Chief Justice Fuller dissented in Champion. The power to prohibit lotteries, he wrote, belongs to the states. He added that giving Congress such a general police power over interstate commerce would defeat the operation of the 10th Amendment. Study guide. What is the police power? Does the federal government have a police power? If the states are barred from policing interstate commerce, then does that power not fall to Congress? The third case, Hammer versus Dagenhart, 1918, considered whether Congress could prohibit the shipment of products manufactured with child labor. Writing for a 5-4 court, Justice Day held that the federal law does not regulate transportation among the states, but aims to standardize the ages at which children may be employed. He added that Congress can regulate commerce, not control the states in their exercise of the police power over local trade. The Supreme Court never invalidated child labor laws under the Due Process Clause. It held only that Congress could not prohibit the interstate commerce in goods made by child labor when its true aim was to intrude into the police power of the states. Justice Oliver Wendell Holmes dissented. He argued that under the rule in Champion versus Ames, Congress could regulate goods manufactured by child labor that were to be shipped across state lines, regardless of its motive for doing so. Study guide. Compare the interpretation of commerce in Hammer versus Dagenhart, Champion versus Ames, E.C. Knight, and Gibbons versus Ogden. During the New Deal, the Supreme Court would reject the proposition that Congress's commerce power was limited by the police power of the states, as was held in E.C. Knight and Hammer. But Champion versus Ames, which allowed Congress to prohibit interstate commerce, remains good law.